Darren is within our legal team, so an employment law specialist of many years standing, and solicitor working for organisations large and small, covering both employment law and data protection issues. So I think we'll hand over first to Darren, and then the guys are going to hand over one to another after that directly.
Good morning, everyone. Now, who would have thought, data protection law, who would have thought 2 years ago that that'd be packing them in? I certainly wouldn't. Now. Okay, start with some fundamentals. GDPR will come into effect on the 25th of May 2018, and it will regulate flows of data right across the EU, and is intended to harmonise data protection rights across the EU. Question I'm always asked first, Brexit. Brexit won't stop it happening. The GDPR needs to be read in conjunction with what's presently the Data Protection Bill, what will become the Data Protection Act 2017, and the new UK Data Protection Act will, it already paves the way for Brexit to become part of UK law after we leave the European Union. First big thing to keep in mind about data protection law, I'm just going to start by talking about some fundamentals. It's principles based, so just like the existing law under the Data Protection Act, GDPR sets out principles, there are 6 of them, plus accountability, which are intended to apply to pretty much an infinite variety of factual situations. The second really big thing to keep in mind, and Jonathan's touched on it, is when you're thinking about data protection compliance and GDPR, split your thinking between whether you've got your employer head on or whether you've got your service provider business head on. I've got the laser on, I'm told. Hang on a second. Is that better, John? Sorry if I lasered anyone in the eye with that. John's saying laser. Yeah, keep your thinking separate, because if you don't keep your thinking separate in that regard, it's really difficult to see the point of data protection law. So keep your thinking separate. Now, yes, GDPR gives rise to lots of change, lots of risk, but the reality is that in the employment sphere, 80% of the law isn't changing that much. It's just that in the past, employers haven't really known what data protection law entails. And small and medium-sized businesses, well, they haven't paid a huge amount of attention to it. And why? Because the penalties for getting it wrong haven't been that huge. Now, of course, with the huge sanctions that, or theoretical sanctions that GDPR brings in, the fines of 20 million euros, etc., will come onto that. There's going to be a far more significant focus in the minds of businesses and employers in terms of data protection compliance. Okay, now there are delegates in this room who are brand new to data protection law, and there are delegates in this room who have been to so many of these seminars that if you hear one more lawyer say 20 million euro fine, you're going to slap me around the face with a wet fish. But with apologies to those of you who have been to loads of them, I think it would be a good idea just to set us up for the rest of the seminar to talk through some data protection language. Personal data. GDPR only applies to personal data, and personal data is data that relates to a living individual, and it can include opinions about that person, and GDPR has expanded the definition so it includes things like biometric data, it can include online identifiers, but if you're carrying around the world's most dangerous nuclear secrets in your briefcase, that's not personal data because it doesn't relate to a person. Okay. Special category personal data, presently known as sensitive personal data. Think information about religion and belief, ethnic origin, medical information, sexual orientation, the really sensitive stuff. Data subject, think employee or consumer. GDPR doesn't distinguish between employee and consumer, it calls them all data subjects, but as I've said, split your thinking between the two and that will give you a much better idea of what's meant by data subject. For data controller, in green, think employer or service provider. Those organisations who determine the purposes and means of processing. And by the way, an employee of a data controller isn't a data processor. The term for that is a recipient. Data processor, as I'll come on to, has got a very specific meaning in law. Processing with a small p, it's a verb. Processing is anything from getting the data, using it, sending it, right the way through to deleting it. processing is different from being a data processor, with a capital. I'm smiling at Fiona because we've had this conversation before. A data processor is an organisation who processes data on behalf of a data controller. So in the employment world, think data processor would be payroll provider processing information on behalf of an employer. And finally on this slide, the Information Commissioner's Office, or I'll be referring to them as the ICO, think regulator. In the UK, the ICO is responsible for enforcing data protection laws. Elizabeth Denham's the Information Commissioner at the moment, Canadian lady, and she really knows her onions. Okay, principles. If you can get to grips with data protection principles and understand that everything flows from these principles really, then you're 9/10 of the way there to really understanding what data protection law is all about. To give you a high-level overview of what the data protection principles are, the first one requires lawful, fair and transparent processing. That basically means that you've got to comply with all relevant laws and you've got to be really upfront with people and transparent about how you use their data. The second one up there in orange is purpose limitation. That really means that you can only use the data for the purpose that you initially intended to get it. And if you can get clear in your mind as an organisation why you're using personal data, so what the purpose is, that makes applying the next 3 data protection principles much easier, because data minimisation means that you use the minimum amount of data possible to achieve the purpose for which you collected it. It needs to be kept accurate and up to date, that's the accuracy principle, and then when it's not needed anymore, you get rid of it. So that's data minimisation. And the last one, integrity and confidentiality, that basically means that you use appropriate means to keep people's data safe. And appropriate means isn't defined anywhere, so you need to decide what is appropriate security by reference to the data that you have and what you use it for and how sensitive it is. Now, if you can see, all of these feed into accountability. That's a new principle that's been introduced by GDPR, and the concept of accountability is pervasive, because a big change for GDPR is that whereas before complying with the Data Protection Act was fine, that was kept you within the law, under GDPR you now have to demonstrate how you're complying with GDPR by reference to the right paper trails, having gone through the right mental processes. And if you can't demonstrate how you're complying with GDPR, that can later be a breach in itself. So there is a much bigger focus on process, method and being able to demonstrate compliance, not just saying, well, we comply. And that's really what accountability means. In practical terms, the ICO are saying, don't make it a box ticking exercise anymore, guys. It can't be box ticking. You need buy-in from the board down, and you really need to put a privacy framework in place in terms of documentation and understand how you're protecting people's rights. Oh, turn the laser back on again. I don't want John on my back. Sorry, John. Right, okay, this one. Processing conditions. If you understand principles, you then, thank you, you then understand, the next thing to understand is processing conditions. I'm not going to go through any detail in this, we'll be coming back to processing conditions in the QA, but when you hear the word processing conditions mentioned, think valid legal reason for processing data. That's all it means, valid legal reason for processing data. And what this mind map shows is that there are 6 processing conditions for normal personal data, 10 for sensitive personal data, and you have to know which one. Now, the reason I'm flagging this up at this stage is because one of the processing conditions in the employment context has always been consent. Employers put in the employment contract that the employee consents that they have to agree to the employer processing their personal data, and employers have always thought, well, that's fine, that's the right processing condition in employment law. But under GDPR, the standard for consent is much higher. And the reality is that the regulators are saying it's going to be difficult or next to impossible for employers to rely on consent in future because of the inequality of power between employers and employees. It can never really be freely given. So the headline from this point, and sorry to use legal language, but consent in employment law is now a dead dog, pretty much. You might be able to breathe some life into the dead dog in some circumstances, but consent in employment law is pretty much dead. So what processing conditions can employers use instead? Well, there are some, and we'll talk about those in the Q&A, but the fact that you can't use consent anymore as a processing condition doesn't mean that employers can't process data. But what's going to become more important is that you understand the alternatives, and we'll draw that out in the Q&A. By the way, I've talked about principles and processing conditions. The detail of what all that means is in your pack. It'll be there later on, and we'll draw it out later on. The last couple of slides have referred to audits being the only way to go. They're emblazoned on the slide. So what does that mean? Well, Kevin's going to be talking to you in a minute about data mapping and process flows. But the point about audits is this from a legal perspective. If you haven't process mapped and audited what you're processing, who you share it with, where it goes, you can't actually understand as an employer or a business how you're complying with the data protection principles. And if you can't understand how you're complying with the data protection principles, or you can't understand what your processing conditions are, GDPR compliance efforts, they're going to be really hard for you, really hard for you. So what Kev's going to be talking to you about in terms of audits and process mapping, that's actually the nuts and bolts of what you need to do to achieve compliance. When Kev talks about process mapping, you can use the most expensive, swanky data flow mapping software. You can use whiteboards to map out what your data process flows are. You can use good old post-it notes, it doesn't matter. But the point is, within GDPR, you're going to need to know what these data process flows are, and Kev will talk to you in more detail about that. Okay, issues for employers, really high level overview. Notification, left-hand side in purple. At the moment, employers have an obligation to notify the ICO of their processing activities once a year. You have to pay a fee. If you don't do it, it's a criminal offence. At the moment, in future under GDPR, those notification obligations are disappearing, but fees aren't disappearing. And the chances are, we don't yet know what the fees are going to be because the ICO haven't told us, but the chances are that fees are going to be higher. So first point around notification in purple, notification obligations are going, fees aren't. Privacy notices, in the employment law context, privacy notices are nothing new. Historically, employers have always had to tell employees what they do with their personal data, but the big difference with GDPR is that the quality, quantity, granularity, availability of information that we give to employees about what we do with their personal data is greatly expanded. And no need to look now, but on page 9 of your handouts, there's a full list of all of the stuff that needs to be included in privacy notices. It needs to be concise, transparent, and easily accessible, and in clear and plain language. That's what GDPR says. So we're moving away from any concept of legalese, confusing double negatives. And remember, if I'm saying to you consent is a dead dog, well, if employees aren't going to be consenting to the use of their personal data, what's their protection? Their protection in the new world is going to be better quality privacy information in privacy notices. So be thinking away in the employment world, away from consent, because actually thinking about it, employees, they can't really consent. It's in the employment contract now, they sign the contract, what can they do? But actually, really valuable information for them is going to be in privacy notices, and it's going to be those privacy notices which are going to be super important in the new world. Individual rights, at the bottom in green. GDPR beefs up existing individual rights around the right to object, the right to erasure, rectification, restriction, data portability. Well, data portability is a new right, but the point is that GDPR, this isn't the, people are talking about GDPR as if it's the genesis of data protection law. It isn't. It's kind of, Deuteronomy or Exodus or something. We're a long way down, or Brexit maybe, we're a long way down the road there. So these aren't new rights, and under the existing data protection provisions, many of these individual rights, apart from subject access, which I'll talk about in a minute, didn't really gain a lot of traction, and I don't see them gaining an awful lot of traction in the new world either. So if you take, for example, the right to erasure, people are talking about it in the context of, well, can employees ask their line managers to delete personal data? Answer, almost certainly not. They pretty much can't do it now most of the time. And that right to erasure is predicated upon the processing condition being consent. And in the new world, employees aren't going to be able to rely on consent. So it's a slightly more complicated than that, but these individual rights, they're not going to be the big issue in the employment law world that people are suggesting at the moment. Similarly, in relation to the right to object, data portability, brand new right. When, you may have read about this, when the right is triggered, people have the right to have their data transferred from an existing data controller to a new data controller. Again, it's going to be a big issue in the commercial world, and I'll happily take questions on it when data needs to get moved from one service provider to another. In the employment law world, it just is not going to be a big issue. Changes to subject access. This is for employers. This is big news territory now. This is the really big stuff. At the moment, employees have to make a subject access request in writing. They have to pay £10, and they have to, employers have to respond within 40 days. In future, the default position will be that subject access requests will be free, and the employer will only have 1 month to respond. That time limit can be extended, but basically the time limit's getting shorter. Other practical points, £10 doesn't seem very much, £10 to free, but actually what's going to happen is, what happens at the moment is employers get a subject access request in and they say, well, send us a tenner, and then 8 times out of 10 they never hear from the employee again. That's going to change. Second big point, GDPR won't require subject access requests to be put in writing. So you're going to need to be training your people around how to spot subject access requests. The amount of mandatory information that needs to be provided in response to a subject access request is increasing. Huge point, the combination of it's easier and it's free to make subject access requests coupled with employment tribunal fees no longer exist mean that in reality the risk landscape for employers is changing hugely. It's changed now, it's changing hugely because information is going to be easier to get, quicker to get, cheaper, and at the end of it there's no fee for an employment tribunal claim. That's something massive to bear in mind. I'm getting the 2-minute sign. Last point on subject access, criminal offences. I've been asked a few times in the past, look, can't we just delete this so we don't have to disclose it? And I've always said no, because that's always been contrary to the Data Protection Act. In future, that's going to be a criminal offence. Criminal offence. So I don't recommend it. Last point then on breach notification. Okay, breach notification for employers. Most employers at the moment don't have a mandatory obligation to tell the ICO about data breaches. And remember, data breaches, it's not just where you get hacked. Data breaches are, you send an unencrypted email containing personal data to the wrong recipient, or you get a power cut and your system goes down and you can't access personal data for an hour or so. They are data breaches. Now, a couple of points. Firstly, when you only have to notify the ICO when the rights and freedoms of employees or data subjects are affected. But you still have, even if rights aren't affected, so no privacy information leaks out at all, if there's been a data breach, you still have to keep a record of it to comply with your accountability obligations, and the Information Commissioner can ask for those records at any time. Secondly, really important point, having to tell the Information Commissioner and record data breaches, that's the Information Commissioner's window into your soul. How are they going to know about data breaches? Because you're going to be telling them. And that feeds into action from the ICO, the potential for fines. So that's really how the ICO are going to have a primary mechanism for finding out which employers, which businesses are breaching GDPR. Final point, fines, because I think I'm pretty much out of time. Yes, they're potentially massive, £20 million, blah, 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 blah. We've had so many questions about the £20 million fine that we're going to deal with it specifically in the Q&A, so I'm not going to deal with it in detail now, but yeah, 20 million, it's scaremongering. You're not getting fined 20 million quid. But that doesn't mean that you shouldn't be concerned about GDPR and concerned about compliance, because I'll talk about fines when we do the Q&A. but there are other reasons as well, and other mechanisms that the ICO can use and data subjects can use to enforce their rights, and we'll talk about those.